Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley of Malone Hatley PC, where we are truly your partner in divorce and estate planning. Today, I'm joined by Rebecca Malone and Mr. Dan Cuneo, and what we're going to talk about is something that doesn't get a lot of attention, and I think that's divorce as a stay-at-home parent. As we've seen, it used to generally just be, mothers were stay-at-home parents and fathers went out into the working world. We're seeing an evolution now where it's a little bit more gender neutral as to which one will be the stay-at-home parent. And I think that gender neutrality has started creating a lot of interesting implications for what the stay-at-home parent can expect through divorce and what the working parent can expect through divorce. So today we really wanted to talk about that stay-at-home parent and what they could do to start protecting themselves and what they can expect through the divorce process. So Rebecca, I want to kind of toss it to you to start talking about what really can a stay-at-home parent start doing to prepare for a divorce.
Sure. So figuring out the finances is the biggest challenge, and who's going to be paying for what, who's going to be living where, while trying to maintain some stability for the children. That's going to be the most urgent situation most of the time with a stay-at-home parent. So what we want to focus on is how quickly can we get something into court, get in front of a judge where we can put a temporary order in place and just have that reassurance. Who's paying the bills? Is there going to be support? How much is it going to be? And then that way that's kind of settled while the case is progressing and while everything else is going on that needs to happen.
Exactly. And Dan, can you kind of walk us through what it looks like, what is necessary to get financial information put together so that you are prepared?
Sure. I want to add one thing to what Rebecca said, because it's absolutely imperative to get into court to receive financial support. But it's also, I always advise clients, what is that support? Like, what are your finances? You have to know that it will help out your attorney too. So it's getting into court and also knowing what's in the checking account, what's in the savings account, what's in the retirement accounts, what does your debt look like, what does your utilities and bills and just everything look like, so we can help when you get into court, that we can show what are those expenses. And it ties into your question as far as preparing for that. What are those reasonable expenses? And the jurisdictions that I'm licensed in, the courts are going to look at what are the reasonable expenses of the spouse that's asking for support. And then the court is going to look at, well, what can the other spouse be able to support? Even though you have X dollars that you need, that doesn't mean that the other spouse can actually provide for that. So if you're in a situation to where one of the parties has to vacate or leave the marital home, then we want to make sure we're getting into court ASAP, because what Rebecca said is so important. That data filing really just sets the tone for everything, not just the movement of the divorce itself, but making sure you're getting the finances that help you so you can keep everything at least on a status quo. But what we will need as practitioners in these types of proceedings is copies of bank statements. Start with the most recent. And I usually ask for a year back, just so we can look to make sure that everything is somewhat copacetic, in the sense that we don't see any things going out but not coming in, right? Or there's other accounts that we're not really too familiar with. And then we want to get a copy of a current mortgage statement so we can be able to present that to the court. And then if you're representing the client who's in need, if they're working, a copy of their most current works paycheck. But then also, if they're not, why are they not working? Are they a stay-at-home parent, right? Because you could be in a situation where you're just a spouse that's not working but no kids, or you're a spouse that's not working and you have kids, and that need is there because you have to be able to stay home for the children. Or maybe they're in school and you're just trying to apply for a job, but there's nothing available that really kind of fits within that schedule. So I want to talk to my clients as far as what does that look like, and why are you staying at home?
I think that brings up a good point. A lot of times we look at a familial situation with a stay-at-home parent and a working parent, and it may be obvious to the family, but we've got to start telling the story to the court. because it should be expected that the attorney for the working parent is going to try to jump on the idea that you're a stay-at-home parent. They're going to try to, I don't want to say exploit it, but they're going to try to say that you should have some sort of income attributed to you. Dave, can you kind of talk about what imputation of income is?
Sure. Imputation of income is usually a situation where you have one of the parties who is either not working, is underemployed, or just decides to take a lesser paying job, which is somewhat underemployed, but they think that they can achieve what they need to based upon the current status. Meaning that when we're in court, if I'm representing the client that is uh, relief is being sought from, then we're going to look at the other side and look at what their current work status is, what is their work history, and be able to determine, can we impute more? Meaning, can we ask the court to say, you're earning X dollars, but based upon your experience or based upon the workforce or the jobs that are out there, we think you can earn Y dollars. And then the court would impute the Y dollars to that individual. That doesn't mean that person has to go out and work that job or work those hours, but the court will say, we're going to impute this dollar amount to you. And that's so important because if you're representing the client to where relief is sought from, then you want to make sure that you're doing your due diligence in making sure that that person who is underemployed or trying to impute is imputed the correct income, because it's going to have implications as far as potential spousal support, potential child support, and then payment of expenses. Because in the proceedings that we've been discussing, at least in the jurisdiction I'm licensed, they're called a PDL, which is just a fancy Latin word for penende lite. And it's just a temporary motion. And although temporary in nature, I can tell you in my 20 plus years experience, usually temporary becomes permanent. It's rare that the temporary switches to something else, absent exigent circumstances that happen along the way. So you really want to treat this more as a mini trial. It's an evidentiary hearing, but there's just so much implications that come from this that you want to make sure you're doing your due diligence. And if you're going to impute income, make sure that you're filing the proper motions and the request with the court, but also make sure that you get the proper expert involved, because you want to make sure that who you're getting involved is familiar, not just with that area to where we're trying to impute income, but also familiar with the court and the judge that you're in front of, because that person will know what that judge is looking for and how that judge usually would rule on certain evidence that's being presented.
Mm-hmm. Yeah, and the imputation of income is always very interesting to me. Rebecca, can you kind of walk us through where you're licensed at? Is there any reasons why the court would refuse to impute income to a stay-at-home parent?
Sure. So, in general, what the court is looking for is prior employment where you've made more money, or just generally you were employed if now you're not employed. Um, if a party is completely disabled and they're unable to work for some reason, that could be a basis for it. Also, in special needs situations. So, if you have a child that has special needs, they have to go to multiple doctor's appointments, they're undergoing certain therapies, things like that, that just make it impossible to have a reasonable work schedule, because you're always dealing with whatever is going on with that child. That's going to be a valid reason to avoid any sort of imputation of income. Most of the time, if someone's able, physically able to work and they don't have any sort of limitation like that, the court is at least going to impute minimum wage. And so there's a presumption there just to get that little bit of income, which doesn't necessarily mean that they won't still receive support. It just won't be in the exact same amount as if they were truly making $0.
Mm-hmm. And isn't there something about if the children aren't yet the proper age for compulsory school
Or
that the court won't impute income?
Yeah. So if you have a parent that's taking care of kids who are under 5 years old, then there's not going to be a presumption for any sort of imputation of income. The presumption is that you're a full-time caretaker, and probably it would cost more to put them in full-time childcare than you could
Mm-hmm.
reasonably make, if you went back to work. And so until they're school age, you absolutely don't have any sort of basis for an imputation of income argument. Now, if you have children that are already in some sort of pre-K program or, part-time preschool or something like that, then again, that argument could come back up. And so that's something to look at and be aware of before you go in and ask for temporary support.
And Dan brought up a very interesting idea that I think is lost on a lot of people, that first hearing, that PDL hearing or the PL hearing is so important. How do you prepare, Rebecca, for that first hearing? What kind of evidence do you look for that first hearing? And how important would you say that first hearing is?
Yeah, so it definitely does carry a lot of weight. It carries a lot more weight than the court would have you believe. Getting the financial records, like what Dan talked about, is going to be so essential. If you've been a stay-at-home parent, you may not have access to all of the financial records, but you should be able to put your hands on at least a tax return. Maybe you can get, W-2 statement for your spouse, getting access to mortgage documents. That's all going to be really important right off the bat. A lot of the courts in Virginia will require, even if you haven't done formal discovery yet, that you exchange certain things in advance of doing your temporary hearing. So you have to provide like an income and expense worksheet. You have to provide your tax returns, recent pay stubs, things like that. Or else the court will say we can't have the hearing if this exchange hasn't been done beforehand. And so, at least you'll have some documents in place, but that's also why we might want to pursue discovery very quickly, or very, soon with filing or immediately after filing, so that we can have the right sort of documents in hand when we go in for that hearing. If you go into a hearing and you're kind of half blind and you say, I think this is the other side's income, and then later you get discovery responses and find out, oh, they're making a lot more money. It's not easy to go back and say, oh, I actually, need more support, or they're actually making more than what we initially presented. Absent some sort of emergency, the court is going to keep you with whatever that temporary order is until your final trial. And at the final trial, you can argue for adjustments, to be made all the way back to the date of filing. But there's a really strong presumption that the court was probably right, or at least close to right, when it made the first order. And if it's been working, then they're going to say this is the presumption, and you're sort of fighting an uphill battle if you want to make a modification at that point.
Yeah, that's exactly right. It's extremely important to properly plan for that first PL motion. And we keep talking about how important it is to get into court quickly. But the reality is there's more than one party involved in getting in court, right? We have us, we have the court system itself, and we have the opposing party. So Dan, what do you do when the higher earning spouse is dragging their feet or refusing to cooperate on setting a court hearing?
Unfortunately, that's a great question, and we see that all the time. It's documenting. It's if they are represented, reaching out to the other side, hopefully trying to come to a resolution pending the hearing or even pending trial. Because these PDLs, I heard you say PL in some other jurisdictions, they're timely, they're costly, and if we can resolve it, that is at least somewhat favorable, or without at least compromising or jeopardizing any rights, that's always the best path forward. But if not, and that other side just being obstinate or just really doesn't care because they think dragging their feet will be advantageous, it may be right now, but in the long run, big picture, it shouldn't be. And that's us as practitioners have to just document that. And that's sending the letters, sending the emails, trying to make the offers, getting in, just setting a hearing with the court and properly noticing it up to the other side. But also in the interim, doing discovery too. I agree with Rebecca. Discovery is so imperative. And at times, we don't want to rush into court to get that date without those documents, because Rebecca's right. It's a hard hill to climb when you're trying to deviate from what the court ruled on, and in trying to exceed that, it's so challenging. To where if we have that documentation up front, that might facilitate settlement, but also, if not, will aid in the way that you represent your clients. And the attorneys that I've managed in the past and currently manage, I'm a big proponent of discovery, especially right in the beginning. It sets that tone. Now, there are cases where we may not need it, and that's fine. So I'm not advocating every case it requires discovery, but most will. And that's just us doing our job as lawyers or practitioners. It's the due diligence. It's hard to advise a client whether or not something's a good deal if we have no idea what's out there. And you can send those letters saying that we advise you to do this and you didn't want to do the discovery. It just makes me uncomfortable as a lawyer to even really propose that and support that, because you're doing such a disservice. One of the things that I've learned when I send out discovery, and everyone likes war stories, right? I think people like to hear them, they learn from them, at least I do. And I always request applications that someone's applied for a loan or a credit card, because more likely than not, you're going to see people inflate their income. And I've used that against the other sides where, oh, I see you're earning X dollars. Well, it doesn't say that on your income and expense statement. So were you lying on your oath here or lying right now to the court? And that's just an easy way to impute the higher income and to put into question the veracity of the other side. And courts put a lot of emphasis on the truthfulness of the party testifying or the evidence being presented, because usually it's going to be one spouse and the other spouse. Now, we may have the expert, which is a vocational expert, come involved. So you may have two experts if you have a counter one. But usually, in my experience, it's going to be one spouse and the other spouse testifying.
That's, I love the idea of using the credit applications. That's one of my favorite tools, because, we all know that on some forms we try to people will try to reduce the amount of income they have, while on other documents they try to increase the amount of income they have. And especially where somebody is not a classic W-2 employee, right? A W-2 employee is somebody that goes to work every day, they collect a paycheck, they get a W-2 tax form at the end of the year. If they're a 1099 employee, where they're a contract employee, or a K-1 employee where they have an ownership interest in a business, those credit applications become so imperative to try to prove income. One of the things I advise my clients, because we do want to move fast on the PL motion, and some practitioners, some I'm not going to say practitioners, but some opposing parties will drag their feet on providing discovery, is to go get what you think you can get, right? Get bank account statements where the paychecks are deposited into. Get last year's tax filings if you have access to that. Something that would get us to within a stone's throw of an accurate number. And then we can go from there.
Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.